Hello everyone, I'm Ankit and you're watching StudyIQ IAS. And in our today's video, we are going to understand some of the contentious provisions of the WAQF Amendment Bill of the year 2024. Now, this bill was introduced by Government of India in the Indian Parliament last year, and since then it has been referred to a joint parliamentary committee for its consideration. But overall, the provisions of the particular amendment bill has elicited a widespread criticism across India. For example, All India Muslim Personal Law Board, which represents a significant portion of Muslims in India, it has announced a nationwide agitation against the provisions of this bill. Similarly, Imarat-e-Sharia, which is a prominent Muslim organization based in Bihar, it has called for a boycott of Chief Minister of Bihar's iftar party. Similarly, India's Congress, which is India's principal opposition party, it has called this bill as an assault on constitution and an attempt by the ruling party to keep the society in a state of permanent polarization for its electoral gain. So let us understand in our process, first of all, what is a meaning of Waqf. Now, Waqf is a property which is dedicated primarily and exclusively to be used for religious or charitable purposes under the Islamic law. And once I designate or I give or I donate a property as a Waqf property, that property can't be sold in an open market. So technically, once I designate or I donate a property as a Waqf property, the ownership of this property gets transferred from me to that of Allah, making this process an irrevocable process. Now, as Waqf property are bestowed in the name of Allah, in the absence of any physical tangible entity, the management and administration of this property rests with a person known as Mutawalli. In some cases, this Mutawalli is also a state-based Waqf board. Now, to change the provisions according to which the management of these Waqf property are managed under the Waqf Act 1995, government introduced a Waqf Amendment Bill 2024 to readdress some of the issues and challenge which pertained to regulation and management of Waqf property. Now, this amendment bill, according to the government, it can improve the administration and management of Waqf property in India, and it also aims to overcome the shortcomings of the previous Waqf Act 1995 by enhancing the efficiency and functioning of the Waqf board. It also wants to improve the registration process for these Waqf property. It wants to change the definition of Waqf, and also it wants to increase the role of technology in management of such Waqf properties. Now, there are certain provisions in this bill which has actually quoted controversy. First is regarding to representations of Muslims in the Waqf board of the state. For example, currently, this body has exclusive presence and representation of people belonging to Islamic religion. But now with the 2024 Amendment Bill, it has proposed allowing even non-Muslims to be appointed as Chief Executive Officer of the Waqf Board and at least 2 non-Muslim members to be appointed by the state government. Now, this matter actually was referred to the Joint Parliamentary Committee, and this Joint Parliamentary Committee allowed for 2 amendments in this provision. It stated that the appointment shall be of an officer of at least Joint Secretary level officer to this Waqf Board, and also that he or she who will be appointed to the Waqf Board shall have the knowledge of Muslim law and jurisprudence. But even after this suggestion, it does not address the key issue which actually created the controversy, that is the representation of non-Muslim in such Waqf Board of the state. Also, this amendment bill, it actually provides a huge power to the government. For example, if any disputed property, whether that property belongs to Waqf board or that property belongs to the government, that matter was earlier considered or was actually adjudicated by the Waqf tribunal. But now this power has been given to the district collector to adjudicate whether a disputed property belongs to the government or it belongs to the Waqf board. Now, JPC, it accepted an amendment to this provision which now gives the power to the state government not to appoint a district collector but an officer who is more senior to the district collector. However, even still, you understand this will create a problem of conflict of interest, because any officer be it district collector or any senior officer of the state government, when they will decide on the dispute of a property, whether it belongs to state government or Waqf board, that actually creates a problem of conflict of interest, because eventually that person is an employee of the state government, so naturally he or she will have a tendency to give this judgment in favor of state government, and this actually has created a lot of controversy. Similarly, there is a concept called as Waqf by user, which is present in the 1995 Waqf Act. Now, the Waqf by user means that any property, it is treated as a Waqf property based on the long-term usage of such property for religious or charitable purposes, even without having a formal handing over that property as a Waqf property. Which means even if the state board or that property does not have a Waqf nama, that property, if it is used for a long time for religious and charitable purposes, that property will be designated as a Waqf property. Now, several mosque and graveyard, they fall under this particular category, but once it will be done away by the 2024 Amendment Bill, which wants to remove the concept of Waqf by user, it will put a lot of such several mosque and graveyard into the question, and that will create such properties as a disputed property. So by emitting such provisions in the Amendment Bill, it can potentially create long-term disputes and can create long-term Waqf property, and it can create controversies around it, right? Also, 2024 bill, it mandates that every Waqf property has to be registered in a central database within 6 months from the law's enactment and commencement. And this registration will actually allow any government property in the database to be flagged by district collector, and then the state government can actually make an inquiry into the nature of that property, whether that property belongs to government or that property belongs to the Waqf board. But this bill ensures that if you are not registering a Waqf property within 6 months, then you will be forfeiting the right to move to a court in case of any dispute that can happen in future, because we understand properties in India, the ownership of that property for many properties in India can be disputed. Similarly, if the Waqf property is not registered, then you are forfeiting the right to move to court in case of such disputes that happens with the Waqf property in the future. Now, JPC, understanding this concern, it accepted amendments giving the Waqf tribunal the power to extend the time frame for registration in some circumstances. But you understand, it is the Waqf tribunal who have the discretion on considering what circumstances will be qualified to allow for extension of registration time frame. Similarly, the decision of the Waqf tribunal will be considered or was considered final earlier through the provisions of 1995 Act, but with this bill, the decision of the Waqf tribunal, it will or it can be challenged in a higher court of our country, that is the High Court. Earlier it was considered as final. Similarly, this bill has also changed how the Waqf tribunal will be formed. Now it will comprise of a district judge and also an officer of the state government, at least of the rank of joint secretary and above as its member. So in the broader context, we have seen that the government is trying to increase its participation in the dealing of Waqf board, in dealings of Waqf tribunal. That is, even non-Muslim members can be appointed as the CEO or even members of the Waqf board, and also state government representatives can actually be appointed as a member of Waqf tribunal. And also we have seen that the earlier contentious provision, that is Waqf by user, has been done away with in the bill. Similarly, the decision of tribunal regarding any dispute was considered final earlier. Now this can be challenged in the High Court of our country. So this is how the government is trying to make changes in the Waqf bill. What do you think about these changes? Are they actually a measure of reform, or are they threat against the entire property of Waqf in India? Please do let me know in the comments. I'm actually waiting for your responses. And with this, I conclude our today's session.